We are going to record this video today so that I can send out the presentation to all of you when we're done, if you wanted to refer back to it or share it with your team later. So your walkout songs are now going to be saved for prosperity.
Hope you chose well.
I do hope they chose well.
Yeah.
Did you want to share your walkout song with us, Brad?
I probably do Sitting on a Dock of the Bay by Otis Redding, just to throw people off. Make it real chill. Not want anyone to underestimate me.
Absolutely. What about you, Scott? What's yours?
Mine is Times Like These by Foo Fighters.
Oh, I love the Foo Fighters.
That's a good
Yeah.
one.
That's good stuff. Okay, we've got a couple more people and then we are going to get started. So I'm going to mute everybody real quick. If you want to ask a question, you can place that in the chat and or unmute yourself. Brad, are you muted? Okay, so
I unmuted myself. I thought that was appropriate.
I do. I think so. Yes.
Yeah.
And then if you will, flip to the next slide. Let's go ahead and get started.
All right.
Awesome. So today, Brad Ferris is going to present title commitments for commercial. And he is currently our commercial counsel for Chicago Title and Fidelity family of companies here in Kansas, Missouri, and Nebraska. Prior to joining Chicago Title, he served as the commercial underwriting counsel for Stewart Title in Kansas City. And he cut his teeth in the industry as the associate underwriting counsel for First American's Title National Commercial Services Division. Brad was awarded his Juris Doctorate in 2012 from the University of Missouri, Kansas City School of Law, and he completed his Bachelor of Arts in International Studies from Rhodes College in 2006. He is an owner and acts as general counsel for BS Buildings, a company that owns and leases neighborhood retail and residential properties here in historic neighborhoods of Kansas City. And additionally, he has served as the past president of the Southview Neighborhood Association and on the board of the Kansas City Young Preservationists. And he is currently an active board member of KCRAR Commercial, our Kansas City Regional Association of Realtors Commercial Division. Thank you so much, Brad. I'm so glad to have you taking care of us today.
Yeah, happy to be here. And thanks for coming on and listening to me talk about title commitments. It's very rare that anyone actually wants to listen to us talk about title commitments. So thanks for your time. We'll try to make it valuable for you. If there's any questions as we're going along, it's better to ask. I can talk for a while. I'm a lawyer who likes to hear myself talk, so we could keep going for forever if we want. But if you have questions as we're going through, please feel free to unmute yourself and interrupt me, or if you want to type it in, Christina or Kelsie or Scott will interrupt me. And we'll get these questions answered. Does that sound good? All right. So today, what we're going to talk about. When do you need a commercial commitment? And we're talking about the big differences in commercial closings versus residential. It's my understanding most people here are primarily residential in nature and are doing commercial for the first time or doing commercial on one-off type things here and there. So, or you may be looking to get into commercial a little bit more. We're gonna really go into some of the bigger differences that there are, and I should probably state that because real estate is so, you'll hear me say this a bunch of times throughout the presentation, real estate is unique by definition. No two pieces of property are the same. No two pieces of property have the same history. They are as diverse as the people who own them. So nothing is ever going to be able to cover everything in an hour presentation. This is super high level. So if you want to know more or you want to get more in depth, we can keep going. I've been doing this for 10 years and I run into something new every single day because real estate is unique, and that's what makes it frustrating, and that's what makes it a lot of fun to work in. So I'm sure you guys have experienced this quite a bit. We're going to go through next the elements of the title commitment, which sounds as boring as it is, but we're going to give some tips and things to look at as you're going through the title commitment, what you need to be focusing on at a high level. A lot of the stuff that you're focusing on in the title commitment, you'll probably be outsourcing that to attorneys and things like that. But that's these are just so you kind of know what people are looking for generally in the title commitment. We're going to go into some common issues with commercial transactions. We'll do a couple quick tips and leave it open for questions at the end if anyone has any that they decide that they want to ask at the very end instead of as we're going through. But again, if you want to ask any as we're going through, please feel free to interrupt. This will be way less boring if people are talking over me. So any questions thus far?
I don't see any in the chat. Any questions?
All right.
Okay.
All right. So when do you need a title commitment? For residential units or less is not considered to be commercial property. It's sort of a weird definition because if you go apply for a permit at the city and you're doing a fourplex, they're going to treat that as commercial. But for most government financing procedures, you actually are going to be for residential units or less. You're going to be in the residential lending world. So those little fourplexes that you see all throughout town, the ones that are stacked on top of each other, that they built a whole bunch of in the 1910s, 1920s, 30s, 40s. Those are all actually just considered residential. So they're all eligible for government financing if someone is willing to live in one of those units. So, but if you're 5 or more, you're in commercial. So if you got 5 residential units or more, we're in the commercial world. And I say anything else is also commercial, which is just as creative as people can get with real estate, which is why real estate is fun again, because who would have thought 30 years ago that there would have been malls being converted into gaming facilities that people would go watch? I mean, the beauty of real estate is it evolves with us as a society. So, if you're in industrial, agricultural, mixed use, shopping centers, some of these lifestyle stuff, warehousing is big around here, retail, actually, interesting enough, subdivisions are large subdivisions before they get sold to individuals. Those are all going to be considered on the residential side of things. Really anything that people can come up with that is not for residential units or less is going to fall into the commercial world. That begs a question though that we'll get to. What if you're doing a portfolio of single family houses? Are you in the commercial world at that point? This is where it gets a little tricky. In Missouri, it's considered residential, at least in terms of a title insurance perspective. I'm sure a lot of our competitors have had this happen, have gotten what's a nice way to put it? Nice letters from the Department of Insurance saying of Missouri saying that we should not be running the residential portfolios of 30, 40 residential houses through the commercial department. So we run those in Missouri through the residential department, not through the commercial department. In Kansas, it really can be either, kind of just really who you're comfortable working with at that point. I'd run them through the residential department. If it's a mix of Missouri and Kansas, it's going to be running through a residential department because we do not like getting audited and having to pay extra fines for little things like that. So any questions thus far as to when you need a commercial commitment? Because we're going to kind of start moving through this in a different way.
I don't see any questions in the chat.
All right. Well, okay, big point. I got ahead of myself, guys. Sorry. If it's not traditional 1 to 4 family residential building, you're in the commercial world. Think 5 or more, or not resident, not someone's house, no one's living there, it's commercial. That's just your big tip. So what are some of the big differences in the commercial closing versus a residential closing? And it's really, the parties are going to be very different. In a traditional residential deal, you've got what do you have? A buyer's broker, seller's broker, lender, escrow officer, and hopefully no one else if you're lucky, right? I'm sure some of you guys, you deal with the mom and dad or the loan guarantor, those types of things on, those are few and far between. Commercial just gets a little bit more complex on those things. A traditional commercial, you're going to have the buyer, the buyer's employees who might be working on it. If you're working with a large corporation, say you're working with H&R Block and they're buying a piece of property, you're going to have the buyer's employees, there'll be multiple people that you're working with on there. And the buyer's attorney, you're gonna have the seller's attorney, the lender's attorney, you're gonna have an escrow officer, and you're gonna have the title company attorney. They call them underwriting counsel. That's typically what we are too. And I will say, actually, attorneys, and I'm an attorney, so yeah, this is possibly a little biased here, but generally you find that if an attorney's involved, it makes the deal go a whole lot faster and a whole lot easier. They know what they're doing, and they can help shepherd everyone along in a way that I'm sure you guys have been in plenty of these residential deals where it's like herding cats. That just doesn't happen in a lot of these commercial deals once you have attorneys involved. And I can have even more complex commercial properties where you're going to throw in a leasehold owner, leasehold owner's attorney, leasehold lender, bond attorney, city attorney, and like the Port Authority type entity could be involved in there, and all of their attorneys. You're gonna have some easement holders. You're gonna have a title agent. You're gonna have someone who's issuing the title and someone who's doing the escrow on the other side. So you could have one person who's just handling all the money and one person who's issuing the title. That adds another thing. You're just gonna have, there's so many various types of interests that can be represented out there on a commercial transaction that we can't list them all here, obviously, but they're just going to be a lot more people involved. I've had deals where there's probably 80 people copied in on these email chains, and keeping up with those email chains is as miserable as it sounds. It's just ding, 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 ding. It drives you nuts, right? All right. Another big difference is the due diligence process in a commercial transaction is much longer, and there's more involved with it. First, you're going to have what's called a title objection letter that comes out. That's going to be when an attorney has reviewed our title commitment. They're going to take objection to anything that's in there that they don't think is useful for their client. So they will send that they'll have, usually within the contract, it's somewhere between 10 and 30 days to make their title objections after receipt of the title commitment. Then they'll send that to us. We'll make our comments. The seller will also make their comments as to what they will and will not do. Sometimes our goal in this, when we get these title objection letters, is to really make sure your deal gets done. We don't want to get in the way of your deal. I know by the time it comes to due diligence, it's been marketed. It's been negotiated. You're ready to go. You found that buyer finally. Some of these market things will sit on the market for a year if it's $10 million, $50 million property. So we really don't want to get in your way of the deal, right? Like our best bet is to keep this thing moving. So we'll do our best, but if we're saying that something's an issue, it really is a pretty good sized issue. And so then we'll go back and forth with the attorneys to try to figure out how to clear whatever title issues that they have found and that they are objecting to. And it's going to be different on every single one. And the people are usually very reasonable. As long as you're not working with people who are trying to one-up each other with the fighting on the attorney side of things, most people are very reasonable in these things and want to get the deal done because one person wants the asset, the other person wants the cash, and there's no personalization to it like you have in some of these residential deals where it's somebody's home, it's where they've lived for a while. It's not the same level of emotion that's attached to a lot of this, right? Ego gets in the way, but emotion does not. Another big one, surveys. Surveys are big in the commercial world because we don't know what's on the property. We don't know what they look like. A commercial building is going to have more issues that come up because they've been torn down and built 16 different times, maybe not 16, but a number of different times. There's just a lot of issues that can come up with a commercial building on a survey that just don't happen very often on a residential building. So learning how to do a survey read, which would be a whole course in itself. We could probably better to have a surveyor do that one than me. But if you do get a survey in, just a quick tip is look at the building, make sure nothing's going underneath the building. that's 90% are going to be 90% of your problems. If you don't see anything going underneath the building, you're probably going to have some issues. You're not going to have any issues. If there's an oil pipe line running underneath your building, you might worry about that. That might not be something you want to lend on. So obviously timing.
Sorry,
Yeah.
we do have a question about the
Yeah.
survey.
Sure.
Does this survey have to be requested separately from the title commitment? And what is
Yes.
the usual costs associated with the survey?
So title commitment and survey are two totally separate things. So title commitment is done through the title company. Survey is going to be done through a surveying company. So I would, if your lending criteria is such that you're going to require a survey and what's called survey coverage, and we'll get into that a little bit different later on down the road. You do need to order that directly from the surveyor. Usually the buyer is going to have a surveyor they like working with. If not, I've got a number of them. I'm sure everyone else, Kelsie, Christina, or Scott would be happy to share these people with you. We all know the people we like because they make clear, easy to read surveys. And we know the people we don't like because they make hard to read surveys. And we read, I probably do 20, 30 survey reads a week. So it's a lot. And in terms of cost, anywhere from $1,000 to $80,000, depending on the difficulty of the property. So if you're doing a ranch out in middle of Kansas somewhere where there's not a lot of surveyors and it's a giant amount of land and there's not a lot of monumenting that's happening, that could be an extraordinarily giant project because they're gonna have to look for oil wells, all these different things. I've seen those costs upwards of $150,000, $200,000 actually. But if you're looking at a small restaurant, someone's opening up a Culver's or something like that you're financing, and an outlot and a shopping center, that's going to be in that, like, I see those cost $2,000 to $6,000 range, depending on the difficulty of it. So somewhere, maybe $8,000, so somewhere in that range. It does add a lot of cost to your borrower. So if you can get around it, it's a really old building or something like that that's been around for a long time. My other company, we do a lot of older buildings that have been built since 1905 or 1800 something. There's just nothing new that's going to come up on that survey because that building has not had anything done to it in 120, 130 years. So, sometimes you can save your customers some money there. But yeah, any other questions on that one?
I don't see anything yet.
All right.
Yeah.
Yeah, due diligence timing is longer. You'll have anywhere from a 60 to 6 month to, I've seen them go over 2 years, depending on the property and what's being done. If there's zoning that has to be changed, if there's new platting that has to be done, that all is going to affect. So it's not going to be a 30-day, 45-day open and close most of the time. It just takes a little longer. On the lender side, you guys are gonna have to deal with environmental reports. We particularly don't care about them that much on the title insurance side of things, but in terms of due diligence, it's a very good idea to get at minimum an environmental phase 1, because if you get an environmental phase 1 that comes back and shows that there's no likelihood of an environmental issue there, you can shield your liability from any actual contamination that might be on the site. So you do want to look at getting those environmental phase 1s, and if it shows something, then you got to do a phase 2, maybe phase 3 to see how bad it really is. And the last one I want to mention is the buyer and the seller have responsibility for clearing the title issues. On a lot of the residential deals, the residential closers do a whole heck of a lot of the heavy lifting here. That's not how it works in the commercial world. The commercial world assumes everyone is a sophisticated party who is buying an asset or trying to get something for a business purpose. So the onus is on the buyer and the seller and the parties themselves to start clearing all these things. We're happy to help you in terms of saying, here's what we think you should do, but we aren't going to be the ones clearing all of these title issues on these types of things. That's on the parties to do that, because we have no idea what's acceptable and what's not acceptable to a buyer and a seller on a commercial transaction. It's very different. So those are going to be some of the big differences in due diligence. And due diligence is one of the really big differences that you see in the two areas. So if we got no more questions on that, let me move on. Okay. All right, we're already at 2:24. I'm gonna go a little faster. Another big one in the commercial world: endorsements cost money. They cost serious money in some cases. So if you're going to want endorsements, ask for the pricing up front. They can double the price of your policy. A lot in the residential world, there's a number of them. We just give those away for free. In the commercial world, we do not. They go for anywhere from 200 in endorsement all the way up to 25% of the policy premium in endorsement. So ask upfront if you have endorsements that you want. And endorsements aren't as freely given on these. We don't give them away like candy all the time. There are actual things that we want to look at and decide whether or not we can give the endorsement. And I wanted to touch on this, that a lot of the common endorsements, we're going to have further requirements. It's not going to be something we can just automatically give every time. So common endorsements that are going to have some things that you want to get some lead time on so that you don't end up delaying closing when you get to closing. If you're doing any of the Alta 3 zoning series, we're going to require a zoning report or a zoning letter from the municipality or the county, depending on where the property's at, stating that there are no known violations, and these things need to be ordered in ahead of time. If it's a good city can turn it around in 3 to 5 days, a crappy city will take 10 to 20 days to turn those things around. So it's important if you're going to start asking for these things. If you ask for a zoning endorsement day of closing, you might end up delaying the closing. And your customers aren't going to be happy with you if you end up delaying the closing because you didn't ask for something early enough, because we just cannot give those without some of these zoning letters. Now, if you have an older zoning letter or something like that laying around, we might be willing to look at it. We're always very flexible. We try to be as flexible as possible with these things. If you have an older survey, we're very willing to look at an older survey. We don't want to hold up your deal if we can avoid it. We make more money the faster and the easier we close these deals. So, but we do need to look at these things. So if you need a survey and there's not an older survey around, order it ahead of time. If you're asking for any of the survey related exceptions, those are going to be the Alta 17 for the access endorsement. And these are the common ones. There's other ones that we require a survey for, but I want to just go into the high level stuff here. So the Alta 25, which is the same as survey. This is a good time to touch on this, actually. The Alta 25 same as survey is not going to be the same as the survey coverage. Those are two separate things. What an Alta 25 same as survey does is say our title commitment has the same land in it that this survey that I'm looking at does. So you can say the title commitment that I have here shows the same land as this survey I'm looking at over here. And that's really all that one does. Survey coverage is us removing, and we'll talk about this more later, the standard survey exception that would reveal anything that an accurate survey of the land would disclose. The Alta 9 series, for an owner's policy, we're going to for sure need a survey. Depending on the property, we might need it for a loan policy. If you want the Alta 18 contiguity endorsement, we will for certain need a survey on that. So it's important to get those orders in ahead of time if you think about it. Now, obviously, these things sometimes things slide. It happens on a daily basis. We see it. But if you're trying to do best practices, getting it in earlier is better. All right, other big differences.
Real quick, Brad. So the last slide, those are the most common endorsements that you find requested?
Those are the most common ones that require a survey. So there's a whole lot of others that are requested very regularly. They don't necessarily need a survey, though. We can get away with those with an owner's affidavit or just looking at the property itself. But the ones that require a survey that you need to order ahead of time, so you're not delaying closing, because people just get livid with everyone. If you get 2 days before they think they're about to close, and someone comes and says, "Hey, I want this Alta 25 same as survey," and we say, "Hey, we need to have a survey to give you something that says that our property is the same as your survey." and that can take anywhere from 2 to 6 weeks to get. So it's important to order it ahead of time. So the goal here is to let people know the survey, the stuff that you're gonna, if you request it, you should order those things ahead of time. So it's good to know what you want earlier in the game. All right. Split closings are not a thing in the commercial world. I wish they weren't in the residential world. I don't think it does anyone any good in the residential world, but that's the market we live in. If you can avoid them in the residential world, I would highly recommend it. You'll do everyone a huge favor. But the contract governs who issues title in the commercial world. So if Chicago title is written into your contract, and we would appreciate it if you write us in there, but whomever is written in the contract is the company that will be issuing your title insurance policy. Lenders in the commercial world do not have a ton of room for negotiation. Now, if you're doing like a construction type thing, you guys are in the driver's seat. If you're doing the construction loan, you 100% get to pick the title company. But if you're doing a refi and you're sending that type of stuff out, but if it's an actual purchase and sale type transaction, the contract governs. So another big difference that you just don't see a lot of in residential is pro forma policies. The pro forma policy is just what the policy will look like when issued. A lot of people like to have those because then they can see, okay, here's exactly what my title coverage will look like. I can read it. I know exactly what's going on. And it honestly makes the whole thing go a lot easier. People attach them to closing instruction letters and say, close when you can issue me the policy that looks like this. And it makes things go really easily. Another big difference, and there's just not a good way of saying this, weird stuff comes up in the commercial world. Because as we talked about earlier, real estate is unique. It's as unique as all of us, is as unique as the societies we live in. And so you can be creative and be flexible on these deals. You're going to make your customers much happier. We try to be creative and flexible. Real estate is unique, and that's what makes it fun. And that's what makes it frustrating. All right. Any other questions on the big differences before we move on to the elements of the title commitment, I suppose?
I think we're good.
All right. Elements of a title commitment is going to look exactly the same as your residential commitment. It's got Schedule A, it's got Schedule B1, it's got Schedule B2. It's how you interact with each of these that is going to be a little different in the commercial world. It will look exactly the same as you get those. An ALTA form is an ALTA form, and ALTA stands for, we've talked a little bit about ALTA here. It's for anyone who doesn't live in this world all the time, it's the American Land Title Association. They promulgate all the forms that are used throughout the entire country so that there's predictability for lenders on what kind of coverages they will have as they're doing things. It allows us to do stuff on the secondary markets and all those things that have been great for the economy and been terrible for the economy at other times. So, all right, so we're going to go into Schedule A, Schedule B1, and Schedule B2 and talk specifically about exactly what you want to look at on each one of those. All right, and we're going to focus on key items for lenders. If you guys have any questions about what maybe a buyer might want, we're happy to answer it. This one's more tailored to our audience here, being mostly lender clients. So if you got anything else, we're happy to address it. So Schedule A, Schedule A's got your who, what, where, and when of the title commitment. That's really going to be a lot of your great info is in there. So we're going to go through the various parts of Schedule A now, which is going to sound as slow as it is, but we'll give you some tips as we're going through as to exactly what you should be looking for in each one of these. So when you're looking at Schedule A1, that's going to be called commitment, date, and time. The commitment, date, and time is where we have searched through. So we have searched the public records up through the exact date and time of that commitment. So if it says, what's today, the October 18th on there, we have only searched through October 18th. Let's give a better example. Say it says October 10th. We have only searched anything that has come through October 10th. So if there was something filed on October 18th, that would not be included in the title commitment. That's important for a concept that we're going to come back to later called gap coverage, but it's important to remember that you want the title commitment date and time as close to closing as possible because you want to know everything that's out there. All right, Schedule A2 says policies to be issued. 2A is the owner's policy. I would look, if I were a lender, I'd want to look in there and make sure that that's my borrower listed in there. If we've got someone who's not your borrower listed in there, let us know. Something's gone wrong and we want to make sure everything has gone right. Then we have the Alta loan policy. That's going to be, make sure it's your bank in there and make sure it's the right loan amount. If we've got not your bank in there and not your loan amount, there might be an issue with the thing you're looking at. Those are two real simple ones that you're going to look at when you're in Schedule A2. Schedule A3, this is an area where it actually differs quite a bit in the commercial world from the residential world. It's the estate to be insured. In a residential transaction, it's going to be what we call a fee simple estate, almost 99.9% of the time. That's just your big bundle of owning all the property, nothing else, right? In commercial transactions, there's often multiple estates that people are going to want insured. So sometimes there's the big three that we see a lot of are the fee simple estate, an easement estate, and a leasehold estate. An easement's going to be important, especially if that's the only way that you can access that property. You're going to want that right insured in your policy, because then if you want to go foreclose and don't have that easement right insured, you might not be able to access your property and you won't have title insurance coverage for it. If you are giving a leasehold loan to, say, let's go back to the Culvers. I'm gonna go back to Culvers. Must be hungry for a burger. So in that shopping center, say they are only leasing the ground from the place and they're building the Culvers on top of it, and your collateral is that building and you don't really care about the ground. You're going to only want a leasehold estate to be insured there, because you're only going to foreclose against the leasehold estate there. So just, you care about getting that lease back from the person so you can sell that lease to someone else. That's generally how those work. And just a big tip here on this one, if you're going to add an easement after we've sent out the title commitment, it does take us about 2 days to get those easement searches done to make sure that there's no way that that easement right can be wiped out. So if you ask for that on the day of closing, it can sometimes delay closing. And again, we've talked about this. People get annoyed when their closings get delayed. All right. A4, title is vested in. This is where we show who we found owns the land when we search the record. So if that is someone other than the seller, it's going to portend problems in the future. If it's someone else that's not there, it's a red flag, right? It's a red flag. Usually we'll have something in Schedule B1 explaining why that's not the case, or we'll want to find out what's happened there. Sometimes it's a simple thing like the entity changed names and didn't file something with the Secretary of State, something like that. But sometimes it's they forgot to record a deed. Sometimes it's someone's trying to defraud someone and doesn't actually have the right to transfer the property. So that's a big red flag if Schedule A4 is not the seller that's listed in the contract. Or if it's just your borrower on a refi. If it's not your borrower listed in Schedule A4 on a refi, there might be an issue there. Your borrower might be trying to scam someone. So it's important for a Schedule A4 to match up with either the seller or the borrower on that one. And then Schedule A5, we call it the land. This is the description of exactly what we're going to insure. If you know what the legal description is and it does not match up to what we have there, that's all we've searched. So there could be a problem. So it's worth bringing up to us. Any questions on Schedule A? That's going to be all the stuff from Schedule A so far. I know this is really dry, guys, and these are just quick tips to keep you going while you're doing a title review. Title review is, that's the attorneys who do title review. I'll outsource that to the newest attorneys in their firms because it's what it is. So, do we have any questions?
I don't see any questions in the chat yet.
All right. Let's see. All right, so this is what it would look like. I know this is not a great picture, but it looks exactly like the residential commitment that you are used to seeing. All right, so Schedule B1 requirements. This is where we outline all of the things that we are requiring to issue our title insurance policy. I think it's important to remember that title insurance commitment is a contract to insure. So these are all the things that we are saying. You have to do all of these things for us to issue the policy, and that is our contract with you if you want us to issue a title insurance policy. We're going to go over some of the major things that you see in Schedule B1. It's impossible to give you every single thing that you'll ever run into because, again, as we've said, real estate is unique. So we're just going to talk about some of the major ones that you're going to see. And again, here on commercial deals, the parties' responsibility is to resolve everything and bring us the evidence as the title company. It's very different than the residential world. We're going to look at a clean deal versus a messy deal on this one. All right, so the major requirements on a clean deal. And if you get a clean deal, great. I hope you get all clean deals throughout all your life. The trouble is the lower end the deal, the more mess there's going to be on it. The most annoying deals are the $9,000 lots that someone's trying to buy and put a little corner shop or something like that on, or a tire store or something. It's always, and anyway. So on a clean deal, the big things that we're going to require, they're going to have the buyer and seller entity documents. Most of the time on these deals, you're going to be dealing with a commercial deal. You will be dealing with an entity. Every once in a while, there's an individual, but that's rare. Most times it's going to be a corporation, an LLC, and a trust. Those are going to be the most common. You'll maybe see some partnerships here and there. Partnerships have kind of fallen out of favor though. And why do we ask to see all those entity documents? We actually ensure the authority to enter into this transaction. So we make sure that the right parties are signing the documents that are supposed to. You'd be surprised at how often, maybe not you guys in the lending world, you probably see this often, but when someone's trying to close a thing, like, oh, this person doesn't need to sign, and you say, yeah, your documents say they need to sign, and you reach out to that person, hey, can I get a signature? Time to get the signature. I didn't know we were trying to sell this property, and then people get into a big fight, and that's why we ask for it. So another big thing you're going to see in the clean deals, you're going to see a loan payoff requirement. We want to make sure that the loan that's out there, the existing loan that's out there, is getting paid off. We're going to require a deed from the seller to the buyer. They'll place that in escrow. The parties will place all the money in escrow. Escrow will then close, record, send the money and policies out to everyone, and everyone is happy. You have a clean deal. Congratulations, you're done, and on to the next one. Now, if there was only clean deals though, title insurance probably wouldn't exist. So messy deals, that's where we live. That's what anyone wants to hear about. What are our major requirements that you're going to see on the messy deals? Obviously, we're going to still have the entity document requirements. We're going to also want to see entity documents potentially for other parties that are of record or anyone that has a claim of interest to the property. You'd be surprised at some of the weird stuff you'll see. The sovereign citizen who thinks that they have a right to the property, or the people who file an affidavit of equitable interest because they think they had a contract right that got screwed over and didn't do it. There's just all sorts of weird stuff that'll be out there. So we're going to require that those all get cleared in a messy deal. So just anyone who might potentially have an interest in the property, we're requiring that, because we insure what's called marketable title. And this is something that people confuse a lot. We'll put requirements out there and people will say, hey, this person doesn't have a right to the land. Here's why they don't have a right to the land. Great, but we're not a court, right? We insure what's called marketable title. You probably would win a lot of these things in the court, but we are here to tell you what all the problems are and what you need to do in order to have marketable title so you can sell it to the next person without any trouble. That's what our goal is, to get to marketable title, nothing else. So all these times where you get something and you think, wow, but this is unfair. It is unfair. We feel for you. It stinks, right? But because we're insuring marketable title, we still have to deal with all of these things, even if that person might not have a right to the property ultimately. So that's why we raise all those things. And I know we get those questions a lot. What are some other the major messy things? Judgments, get lots of judgments. Bankruptcy, and if there's a bankruptcy on our title commitment, if it's not a really good customer, that's a dangerous one. You know, if you see bankruptcy in there, that's a huge red flag for you. Death of one of the owners, that's often the case, especially if it's an individual that's owning it, or if there's a death in one of the members of an LLC. There's a lot of the time that we don't know exactly what happened to the LLC if it's one member who owns it. So then we've got to figure out, okay, who has the right to transfer this property now that this maybe the entity's dead because the death triggers the termination of the entity. There's a whole bunch of different things that can happen with death that just make things messy.
We do have a question, Brad.
Yeah, what's up?
How can we, as a title company, help the lender clear judgments?
We can tell you who needs to record the judgment. That's really going to be on the parties, though, to get, because we're not a party to their litigation. All we can really do is here are the people who need to clear it. If your borrower has a judgment against them and they don't know why, I'd be suspicious, because they've been served with paperwork. They have, or someone didn't do some searching and bought a piece of property and didn't realize there were judgments against the prior owner. If those are out there and your borrower doesn't know what's going on and the seller doesn't know what's going on, hire an attorney. That's when you get into hire an attorney, because you might need to file a suit for slander of title. You might need to quiet title. There's not a lot we can do because we're not really party to these litigations. All we can do is say, here's what's out there. This is what we found. You need to get a release from these parties. We can help you say, here are the people you need to talk to. But if no one knows who any of these people are, there's not a whole lot we can do either. It's unfortunate, but that's just how the commercial world is. It's the concept of what's called caveat emptor, or buyer beware, applies for the most part in the commercial world. There's not a lot of protections for individual consumers like there are in the residential world. So there's just not as much we can do on those types of things.
So the next question she's asking is,
Yeah.
do we search for the judgment clearing?
Yeah, 100%, 100%. Yeah, if there is a judgment, and sometimes people miss them. I can tell you many times people miss those too. But yes, we 100% also look for the satisfaction of the judgment. If there's not a satisfaction of the judgment out there, that's why we've raised it. So if there is a satisfaction of the judgment, we will not raise it, or we've raised it and we missed it. And if there is, then we say, oh, I'm so sorry here. Well, let's move on, and no need to worry about it.
And then as those releases come through, we would record them. Is that correct?
Yeah, we can. I actually generally like to see the attorney who has the lien record those satisfactions with the court, because A, they've been working with the clerk, they know those people, they've been doing it, and B, if the attorney for the party who's owed the money files the release, it's a whole lot more permanent than if, say, the title company files the release. Because if the title company files the release, the attorney maybe comes back and says, well, hey, hold on, I never got the money, right? But if the attorney who is owed the money files the release, they have the only argument that person has then is against that attorney's malpractice suit, if they don't think they were given the right amount of money. So I generally like to have the attorney on commercial deals. On residential deals, we do them all the time. But on commercial deals, I think it's important to have the attorney who thinks that they are owed money and who got the judgment in court record those. So on judgments. Now, on satisfaction, on other lien type things, we 100% will record those if it's just a regular public record in the county type thing. But for a judgment lien that's with the court, I like to have the attorneys. But that's me. Other people disagree on that one. So, but it's a good question. Very good question. And we can file them if need be. If it gets down to it, we'll do it. All right, what else? Other messy deals. You had multiple loan payoffs. Another big pain in the ass one is individual loan payoffs. There's a lot of people who give, their buddy a $30,000 note, and they put a second lien on the property, and that guy's disappeared, or they just especially if it's an older mortgage, to an individual, they just become very problematic. You get lots of old mortgages that weren't released. We do our best to clear those as many ways as possible. Child support liens, get a lot of mechanic liens, lots and lots and lots of mechanic liens that are going to be out there. And as we're going into a downturn, I have a feeling we're going to start seeing more mechanic liens popping up on deals as financing runs out, or someone doesn't want to liquidate their stock portfolio that's down 60% while they wait on this whole thing to play out. What else? You get some association liens. Association liens, it's not going to be as often as like an HOA lien, but there are commercial associations that are out there on various places that if you're not paying in, they will put a lien on the property. It's not as common as it is in the residential world, but they do exist. Let's see. Okay, yeah, these even more. We got lots of them. I'm mostly trying to give you an of how many weird things come up on these commercial deals. We'll require vendor lien releases, attorney lien releases. Sometimes we need bonds released. Delinquent taxes could be out there. Payment in lieu of taxes can be out there. There's often dangerous building certificates that have been filed. Sometimes we're going to require estoppel certificates for various items that are out there. From a leasehold owner, or maybe there's an association that we need to find out something about, or maybe it's just there's a 24-hour fitness on the property, and there's something that says that there's not allowed to be any fitness centers on the property. So we might require an estoppel certificate from everyone else in the property saying they're not going to sue based on this. Lots of little things that'll come out here. And a lot of these probably sound familiar because businesses are run by people, and the same people who you guys are lending to on the residential world are also running the businesses. So some of this stuff you'll see a lot on the residential world as well. Some of it is unique to commercial, but when it really comes down to it, the same people who run the businesses also buy the houses. So, all right, those are our messy deal things. This is still B1, still going to look the same. Still going to have various commitments out there. I'm going to flip through these and not spend a ton of time on this. All right. Schedule B2. Unless we have any other questions on B1, the requirements, those are going to be all the various things that are out there that we need cleared before we can close. Schedule B2 is what we'll move to. Do we have any questions before we move on?
We have a question about, is there a price point, building size, or other distinction where it might make sense for a buyer or a seller to use a commercial agent only versus paying also for an attorney?
Commercial agent, it depends on how difficult. It's not necessarily a price point. It's more about how difficult is the thing in front of you. I've seen $8,000 deals that need an attorney, and I've seen $10 million deals that don't need an attorney, right? If you get a $20 million deal and it's a clean deal, you're just doing a refi on it, you're just refinancing it, you might not necessarily need an attorney on that. I would hire an attorney, but I'm biased on that one. But it's more of how difficult is this property. I honestly think that I've done the math on this. If you had 2 attorneys working even on your residential transactions, I think it would cost a whole heck of a lot less than than most brokers charge in terms of commission. But I hope there's not too many brokers on the call. But so that could actually end up lower. Sometimes hiring an attorney actually lowers your overall cost in these things because the attorneys know how to shepherd these deals through and get them done in an efficient manner and not delaying closing, being able to get the asset on time, especially in an environment like we are right now. An attorney who knows how to shepherd a deal along and get it closed quickly versus one that drags it out, or people just don't know what they're doing and you end up waiting and you lose some rate locks and the interest rates go up again. You know, the things can happen if you don't have an efficient attorney there. So there's not a great price point or deal size. It's more of a deal difficulty thing that you ought to look at with hiring an attorney versus an agent. The agents are great for marketing the property. They're great for showing the property. But once you get into the due diligence side of things, the agents can walk into the unauthorized practice of law really quick. So they try to stay out of a lot of those issues as well. So I think a good attorney is very useful in most deals. And there's lots of attorneys who it takes an hour, maybe 2 hours to review a contract, and another hour, maybe 2 hours to look over a easy title commitment. You know, you're out maybe $750, $1,000 to have someone who has your back reviewing all this stuff, who's an expert in it. It's so it's a good deal sometimes to have the attorney.
Perfect. I think that answers that. Thank you.
All right. All right, B2. Big difference from residential. B2 actually matters and is important. In your residential deals, I bet most people don't look at B2 all that often. These are the actual exceptions that hit the property. Because on B2 and most residential, it's going to be a plat, maybe a homeowners association, and some sort of condo association, maybe a few easements. These can make or break your ability to use the collateral and the way the borrower intends. So B2 is actually fairly important. So let's start with B2 exceptions. First thing I want to talk about here is what we call our standard exceptions. You're going to hear people talk about standard exceptions quite a bit. Those are considered off-record matters that we have not been able to find. So we call this gap exception. I remember earlier we were talking about the date and time of the policy. This is where this gap exception comes in. If the date and time of the commitment is at, say, September 27th, and it is now October 18th, we haven't searched that entire period. And so we take exception to that period we haven't searched. So what you should do there is ask for us to, and we try to do this on our own too, but if you want to look good in front of your customers, ask for us to bring the search forward. We'll bring the search forward as close to possible as we can. It's not all real time, but we get it pretty darn close. And then you should ask us to delete the gap exception, and we're very willing to do that almost all the time, unless there's some sort of a weird circumstance that happens, so that you are not taking any liability for things that might be in that, what we call the gap between the period we've searched through and the period of closing. Does anyone have any questions on that? That's actually kind of a heady concept. It took me probably a year of working in the industry to really wrap my head around that one. But the big point, delete it. Ask for us to delete it, we will. So yeah, Kelsey, you were saying no, nothing?
I don't see any questions. I know that originally I had been asked what kind of instructions are you looking for from the lender? So I'm guessing that if that would be needed to be included in the lender's instructions.
Oh yeah, absolutely. Yeah, we get closing instruction letters very regularly in commercial, same way as you do in the residential world. They're sometimes a little more detailed, and they usually have that pro forma attached to them that says here's exactly how the policy needs to look. But you know, we can usually delete that gap exception. And mostly because we're asking the owner to sign what's called an owner's affidavit, and they attest that they have done nothing and they have no knowledge of anything that's been filed in that gap period between when we have searched and when the closing is. So we have another one we call parties in possession, and the language I have in there is the actual language that is in all of the commitments, but these are just the kind of shorthands for them. So parties in possession, that's going to be anyone who is possessing the property that doesn't have a recorded interest. So if there's a squatter on there, if there is a tenant on there, we don't know about these things, right? These are not people who have recorded anything. We have no way of knowing that. So again, here's another one and we'll hit this up again, but I want to hammer this. Ask and you shall receive on this. If you ask us to remove this, we will get the owner's affidavit, and the owner will tell us that no other person has possession of the property except for there are certain amounts of rent and tenants. Now, we will take exception to the actual existing tenants. So if it's a shopping center and it's got, you know, a Massage Envy, a Panda Express, and a Little Caesars, great little shopping center. I hope everyone has one of those at some point in their life. We're going to take exception to all those things because all of those leases will predate your deed of trust or mortgage on the property, and you're not able to foreclose those away without getting subordination. And if you do want those to be, this is getting probably too advanced for this call, but there are ways to make those subordinate if need be. But that's the rights parties of possession. Off-record easements. A lot of the time, people have tacit agreements to allow people for parking or to cross for access and things like that, and they just never recorded it. But they have been for the past 50 years letting their neighbor to the east drive across their property so that they can access their thing. They just share driveways and things like that. Those are all things that a survey would disclose. So if there is now on a loan policy, we'll actually delete these without the survey. If it's about $10 million or less, sometimes 15. But you might want to know as a lender that there's nothing out there that's going to mess with your ability to use the property. But again, here is another one: is as the lender, you can ask and receive. The owner, though, will have to get a survey if they want us to take that off of the owner's policy, because that's actually an interesting point that we should. Do I have time to talk about that? No, I don't. It's 3 o'clock. All right. Let's see. I'm going to go fast through a few other things. So standard exceptions, big thing on standard exception, ask us to take them off. Then after that are the specific exceptions. You're going to have easements, restrictions, covenants, oddball stuff, minerals. That's where all those are going to come in. It's important to look through those and actually think, hey, is there anything in these specific exceptions that's going to stop my borrower from being able to use my collateral appropriately? Let's see. I think we've already talked about most of this. This is standard exceptions, what they look like again. Let's see. Again, here we go. Ask and you shall receive. If it's about 15 million or more, it changes the calculus for us a little bit. Tips and questions. Read the commitment. It's important. Don't schedule on a Friday. Things happen too often. If you schedule closing on a Friday, Saturday comes after Friday and everyone's closed. So then I would tip, just schedule in the morning. It's easier to do a closing in the morning because that gives us all the rest of the day to transfer money and get stuff of record. Versus if we get everything in at 4:22, we might not be able to get the wire out by 4:30. So, all right. Sorry to rush through those last couple slides there, but if we have any questions, if people want to stay on, I'm happy to stay on and chat.
We have one outstanding question that I wasn't sure if you were going to get answered throughout the thing. And she was wanting to know if there was a list of endorsements that can be requested. So I'm assuming that would be like a fee sheet.
Yeah. So I suppose there's, the best way to do that is going to be by looking at the rate sheets. There's probably 300 to 400 endorsements out there that you can request. Most of the time, the ALTA, the American Land Title Association, endorsements are out there. They don't always make sense to ask for on every DLA. You don't need to ask for water rights on a deal at 19th and Grand. That doesn't make any sense, right? There's wind and solar type endorsements that you definitely don't need if you're not building a wind farm. And so there's lots of them that just don't always apply. But yeah, there are lists out there. Every title company has their own set of recorded endorsements, and then American Land Title Association also has all of their standard endorsements.
Perfect. Well, I don't see any other outstanding questions, Brad. I think you did a fabulous job. And of course, if you guys want to close with Chicago Title, you can. Oh, I have a question from Karen. Most of us do use an attorney to request the title commitments. We just need to know what the endorsements are there that we can and cannot. So Karen, we'll make sure to follow you up with that. Scott Hannaford is our commercial residential or our commercial sales executive galore. So maybe the best thing that we can do is hook you up with Scott and he can get you set up on those. Christina and I are absolutely ready to help you as well. If you want to close with us, just shoot us over an email. And you will be receiving a follow-up email from Chicago Title with this video and the slides and a copy of what a messy commitment looks like. Thank you, Brad, for that. And thank you so much for joining us today, guys.
Thanks, everybody.
Have a great day. Bye.
Bye.
Thanks, Brad.
No problem.